Hi there, it's Alex Woods here, financial mis-selling solicitor, and I quite recently had a client from the southwest who was faced with repossession proceedings and had a hearing in the county court, and he rang me but a few days before that hearing was due to take place, having exhausted all conventional routes to find someone to help him with the problem of whether he had a valid defence to repossession proceedings on the basis that he had been missold payment protection insurance one day in the past. So that's the scope of this video. Now, I think the first question that anybody's going to be asking themselves is, well, you know, is the missale of payment protection insurance on a second charge mortgage? Typically, that's where payment protection insurance has been typically missold, not on first charge mortgages. And, you know, I have signed this agreement which has secured my property against the loan so that the bank can move in and repossess should I default. So now this is the first question, and I can deal with this immediately and simply by saying yes, in certain circumstances, payment protection insurance may well have contributed to the arrears and to a default on the repayments of the loan, such that it would be inequitable for the court to allow the bank to repossess, or indeed to deploy any of the other available options to it when it goes to court, such as an order, a suspended order, or an order that should the consumer fail to meet a repayment that's been agreed, then they can immediately repossess. Any one of a number of things that are on the road to repossession but don't quite take you all the way to repossession, because obviously the courts don't like the idea of people losing their homes. So the first thing to say is, yes, you may well have a defence to repossession proceedings if you genuinely believe that you've been missold payment protection insurance. And then that comes on to the next point, which is that the issue will be whether you think that the missale of that payment protection insurance product associated with your loan has contributed to you defaulting or to falling into arrears. And that is the key question. And if it has contributed to you falling into arrears, then it would be inequitable, even though the law may be on the side of the lender contractually, because the small print says that they're entitled to repossess if you miss a repayment. And it could well be quite a draconian agreement, and you didn't read the small print very carefully when you signed up to this loan, and you probably ruined the day that you ever secured your property against a loan where a large single premium payment protection insurance policy had been sold. So, you know, that is going to be a bit of a battleground. Now, the other thing that arose out of the case that I had to deal with the other week was, well, okay, what about if they've already settled a payment protection insurance claim? They've already actually agreed that they'd missold the payment protection insurance and repaid with the money. Well, again, the same principle will apply. In that case, that is what had happened. However, the bank had also rejected a claim made on the payment protection insurance much earlier when the client had lost the job. And I think it was a joint policy, and the wife was self-employed. So the payment protection insurance policy claim was rejected because, unfortunately, self-employed people can't claim on the payment protection insurance. So there you have an illustration of where, even though a refund was paid, previously a claim on the insurance had been rejected and had subsequently led to defaults on the loan repayments and to arrears. And you know how the banks sort of steamroll the balance forward as you miss the arrears. It's quite a threatening thing for a person to have, their loan statements produced, and there's perhaps legal fees or overdue fees, late payment fees, and the arrears is growing and growing and growing because of the missed repayments and interest has been added. It's quite an intimidating thing. But you shouldn't be intimidated if you genuinely feel that as a result of the missale of that payment protection insurance, even if it has been refunded to you, it has been a cause of you falling into arrears. And the other thing to note that with this particular case is that the refund had been set off against the arrears, the balance. So now set off is a whole complex area in itself. The entitlement of a party to set off a sum of money in one claim against money that they're owed in another claim. I'm not going to delve into it now. It will depend upon the circumstances of the case. You might want to look at the Financial Ombudsman Service, Google it, set off in payment protection insurance claims. You'll find that they give some helpful guidance on circumstances in which set off may be appropriate, and they may approve of a bank setting off a payment protection insurance claim against the debt, and where it may not be appropriate. I wonder whether it was appropriate in this or in all cases where the consumer may have agreed with the bank a certain amount of repayments, perhaps not the full repayments they're entitled to, but they have been keeping up repayments on the loan, such that it would be somewhat unreasonable, draconian and inequitable for them to use that money that they'd unlawfully taken from the consumer in the first place, the missold payment protection insurance, and unilaterally decided, well, we're going to set it off. It's such an easy and convenient thing to do. You can see that the bank's attempted to do it, but it's not. Might not be appropriate in all cases. And indeed, in this case, I have a suspicion that perhaps, it was an inappropriate thing to do, and it didn't make much of a big dent on the balance, which had grown as a result of the arrears, which has been, at least in part, can be, at least in part, attributable to the missale of the payment protection insurance. The fact that their repayments were that much higher and it became unaffordable, and they'd previously made a complaint that had been rejected. Now, I come on to the penultimate point in the video bulletin this evening, which is arrears. And I think that's where you have to be careful, because I think one has to be very, realistic and detached about the extent to which the arrears on the loan accounts may have been down to your simple inability to meet repayments for whatever reason, and substantially down to your inability to meet repayments for whatever reason. And if the payment protection insurance was a small percentage, for example, of your entire monthly repayments, that might be a good reason to say, well, the banks have got a case here. So I always tend to factor in the arrears situation. If for no other reason than that, even if you do win and you successfully defend repossession proceedings and you counterclaim from payment protection insurance, if you haven't already had the PPI refunded, then you are going to want to restructure the loan, and the issue of arrears is going to be quite significant. So always be realistic about your level of arrears and the extent to which payment protection insurance really has contributed to your current predicament. Finally, I would say that unlike most payment protection insurance cases, you are going to want some level of legal input. Unfortunately, regrettably, that is likely to be the case. There's just such a lot of complexity with these types of cases, and the banks will attempt to. They're not very good at using their discretion between individual cases, and they will attempt to steamroll the repossession proceedings forward. So there's two things. You've got to say to the judge at that first hearing, don't be intimidated. There will be a first preliminary hearing, but it's not the end of the world. It's just the start of a process, and you shouldn't be intimidated by the court or by the other side's counsel, who may have been appointed last minute and just being paid to come in and try and get some sort of order. You should simply say to the judge, look, there's some complexity here. I think the payment protection insurance claim that I believe was missold has contributed to my current predicament, and I think therefore I have a defence, and I would like some time to put together a defence and to see if I can't source some legal advice to assist. And 9 times out of 10, the judge is going to have to adjourn the matter for a later time, and exactly what happened in the case that I alluded to at the beginning of my bulletin. In fact, in that case, the judge was very sympathetic to the consumer's plight. So that's the end of this video bulletin. There's so much more I could say about this issue, but I think you'll probably have to post a comment or email me at info@redwoodlegal.co.uk. But I will just say, give you an idea of costs and things. If I'm dealing with a consumer in that predicament, I will want some money on account. Could be £500, could be £1,000. If we're successful in defending the claim, they will get that back, because my legal bill will be paid by the losing party, i.e. the bank itself. But I will need something on account, and you may have to whistle goodbye to that initial investment, because after having a look at the case, and I have not looked at the papers in this case yet at all, but it may be that I hypothetically look at this case and I decide that the bank have got merit on their side, and the client is facing an uphill struggle, and he may have to settle on the basis of some order. So you probably will have to, in that situation, hypothetically, he might have to say goodbye to a slug of money, and that's sort of figures that we're talking about. Then I will have assessed the merits of the case, and if I think there's a strong case, thereafter I will enter into a no-win, no-fee agreement with the client. Okay, many thanks. I would be somewhat cagey about solicitors who would run the case on any other basis. After all, you are probably at that stage substantially in debt, and a no-win, no-fee arrangement in what is quite a complex legal case is your only alternative, your only choice. Many thanks, and look forward to posting you next time.